efforts. Part of that was me meeting with Sean Abrams, who was then, I think he was an acting National Director of Public Prosecutions, because, we were hoping that we could have, some kind of movement in the Cradock Four case as well. I met with Mr. Abrams. I'm not sure about the date anymore, ma'am, but I remember meeting him at the NPA's offices in Cape Town, because I still lived in Cape Town at the time, where he had promised, that they were going to look into it. The justice would come for us as the families of the Cradock Four.
So, just so you know, he in fact was he wasn't acting NDPP.
Yeah.
He actually was the NDPP at that time.
Thank you for that.
So I assume that nothing further came of that meeting, because according to your statement, you then decided to approach the Foundation for Human Rights and the pro bono team at Gqeberha Hofmeyr.
Yes, ma'am. Other than a tweet from Sean Abrams, nothing came from that. We then published our book in 2018, and shortly thereafter I did then start speaking to the Foundation for Human Rights to assist us, so that they, because by then, ma'am, there really was no movement in the Cradock Four matter. None. It was almost like it had never even existed. So I then approached the Foundation for Human Rights. The foundation then assisted us by getting us in touch with the pro bono team from Gqeberha Hofmeyr, and we, now that we had, some support, legal people that were in our corner, and that we didn't have to pay, because we part of the pro bono, because, ma'am, if we had to pay, we would still be very far from where we are today. So once we were in touch with the team from Gqeberha Hofmeyr and the Foundation for Human Rights, we basically just kind of knuckled down and worked and pushed as hard as we can for us to be able to be here today.
And perhaps you can give a sense of what that team, including the private investigator Brigadier Marion, what they were able to do and who they were able to trace.
Sorry, Advocate. If I can just mention once, ma'am, as part of obviously this push for us to get justice, we had also met with the African National Congress. When I was fired from the SABC a couple of years prior, in 2016, we
please let's take care of that.
Perhaps you can try switching it off.
You can carry on.
Thank you, ma'am. So when I was fired from the SABC in 2016, I was then called to meet with the former Deputy Secretary General of the African National Congress, Jesse Duarte, the late Jesse Duarte. So in that meeting, I was able to establish direct contact with her and her office. So when I was had started working with the Foundation for Human Rights, and we had other families also on board, such as Utendi Simelane from the Noktula Simelane family, Imtiaz Kaji from the Timol family, and there were other family members. We then also reached out to the DSG, as she was called, and we met with them with the team from the African National Congress on several occasions, where again, one of them was Ronald Lamula, who's the former Minister of Justice himself. He had attended some of those meetings. And in those meetings, we again, ma'am, we were appealing to them, for justice. We, basically any avenue that I had, I tried to extract maximum value out of it in terms of making sure that there was movement in the Cradock Four case.
Thanks for that additional step that you took. At paragraph 152, you point out that your legal team, together with Brigadier Clifford Marion, were able to trace individuals and determine who was living and who was not. Perhaps you can just read paragraph 142, at least 152 into the record.
Paragraph 152 reads as follows, ma'am. Extensive investigations were carried out by Mariam, which will be described in detail when he's called to give evidence. 14 living persons of interest were traced, and the deceased status of some 21 persons were confirmed, while 14 persons could not be traced. Now, all information uncovered was handed over to the assigned investigators and prosecutors. More than 140 interactions and communications took place between Marion, my attorneys, and the assigned police investigators and prosecutors between 20 July 2019 and 2 July 2021. These efforts were aimed at supporting and enabling the work of the Directorate for Public Crimes and Investigations. I think that's what the DPCI stands for. I'm sorry, ma'am, it just excludes me now.
Directorate Priority Crimes and
Yeah,
Investigations.
thank you, sir.
And my lady, that list or chronology is 41 to that civil application, which will be part of the bundle that is handed up on Monday. Now, you also point to correspondence between your attorneys and Advocate Chris McAdam, who at that time was with the NPA's Priority Crimes Litigation Unit, the PCLU. And he advised on 23rd April 2020, and this is set out in para 153 of your statement, that a decision in the Cradock Four case could only be made once the investigations in the other TRC cases, such as Pepco 3, Motherwell bombing, and the Mkulu cases have been finalized. What's your response to the information you received that the MPA is saying that your case must wait until several other cases have been finalized?
Again, Judge, in that instance, I couldn't believe that what we were hearing from the NPA. Why was the Cradock Four case and a decision on the Cradock Four case dependent on what happened in other cases? The Pepco 3 matter is as important a case as that of the Cradock 4. And all of the other cases, the Motherwell bombing matter is as important a matter. But one does not necessarily depend on the other, because whatever happened in the Pepco 3 matter, other than perhaps the proximity in time, and maybe they were the same people involved, but the Pepco 3 matter is the Pepco 3 matter. And a decision on the Pepco 3 on the Cradock 4 can't depend on whether one other case is finalized or not.
Hence you objected to that proposal.
Yes, ma'am. Of course, we disagreed completely because, I mean, I thought it was another way of them just stalling because it's ludicrous, ma'am.
And then you received even worse information. You say in your statement, paragraph 156, that your mother, on the morning of the 1st of April 2020, received a call from the investigating officer, Colonel Makua. Can you explain what that conversation was about?
Ma'am, I received a phone call from my mum telling me that she had just gotten off the phone with Colonel Makua. And Colonel Makua had basically informed her that the docket of the Cradock Four case was missing. Yeah, and again, ma'am, how does the docket go missing? It's not supposed to.
And because you say in paragraph 156 that your mother was emotional, you called the colonel.
Yes.
And can you explain what the colonel told you?
Yes, so I then did call the colonel and advise him that who I was and that I just received a phone call from my mother and that please could he, talk to me or repeat what he had told my mother. The captain then told me that Advocate McAdam had advised him that the docket had been handed over to someone who claimed to have been sent by Advocate Gqeberha, who was the former acting NDPP. Colonel Makua indicated to me that he was deeply troubled at what was happening with the investigation. He said to me that he did not believe that the docket went missing accidentally, and he was concerned that powerful forces were protecting the suspects, in particular the high-ranking suspects.
And what did Colonel Makua advise you to do?
He advised me to take up basically, he told me that I needed to go to a police station and that I needed to lay a charge of a missing police docket.
And we'll get to that. Your statement reflects that you thereafter, on the 1st of June 2020, called the former investigating officer, Captain Masagela.
Yeah.
Why did you choose to call the former investigating officer, and what was your discussion about?
As part of that conversation with Colonel Makua, who had informed me of the missing docket, he had also mentioned, obviously, that, he had done a lot of work, in that docket, and then that it was handed to him by the previous investigating officer who had since retired, Captain Masagela. Obviously, I called Captain Masagela just to try to understand what had happened. The one statement that struck me in that conversation was with Captain Masagela. He said that the prosecutors had failed him. When I inquired what he meant by this, he said every time he sent dockets through to the NPA for a decision or for guidance, they would take ages to come back to him, if they did so at all, ma'am.
So you then attempted to take the matter further as advised by Colonel Makua. And it's reflected in your statement that Cliftecker Hofmeyr engaged in several communications
Yes.
with the NPA regarding the status of the original docket and whether there was a theft investigation on the go. At 162 of your statement, you say, without any meaningful response, I was left with no alternative but to open a criminal complaint of theft in relation to that docket.
Yeah.
Can you explain to the court what steps you took and how that worked out?
Yes, ma'am. So by then anyway, by then I was still living in Cape Town. So I went to the Caledon police station, which is in central Cape Town, to go and lay or to open a docket or a charge of theft of this missing police docket. They gave me the runaround there, ma'am, in that the guys in Caledon said that because the docket had allegedly gone missing in Pretoria, I think, so I couldn't open a case in Cape Town, that I needed to go all the way, I think, to the Silverton or Silverton police station to go and open a docket. Again, ma'am, for me, I mean, it's insane. If I have to report a crime, or at least, why do I have to go to the nearest police station in Pretoria to go and open a case of a missing docket into the Cradock Four? Why couldn't I just be allowed to open the case in Cape Town and then they transfer the docket or the case from Cape Town to Silverton, and then for the guys at that site to start investigating and all of that?
So that you did on the 11th of September 2020, or you
Yes.
tried to do at least.
Yeah.
And because that didn't work out as you've explained, in paragraph 164, your attorneys made the attempt on the 1st of October 2020 at Silverton Police Station. And how did that work out?
My attorneys, ma'am, they tried to obviously then go and open the case in my behalf. They were also denied, ma'am, I suppose because they weren't me or whatever the case was, but they were also prevented from actually opening up a case at the Silverton police station.
In fact, they said something curious. They said that the attorneys, they couldn't accept it because only the Independent Police Investigative Directorate of South Africa could investigate that docket, even though it didn't go missing from the police, it went missing from the NPA.
Yeah.
And then your attorneys were forced to take further action, which you set out in 165. What steps did they have to take to eventually get a case opened?
So my attorneys addressed a letter to the Minister of Police as well as the National Commissioner of Police, ma'am, seeking their intervention. And once they had stepped in, this eventually resulted in the DPCI confirming in a communication on 23 October 2020 that a criminal case had indeed been opened for defeating the ends of justice and theft of a docket as per Silverton. And then they gave us the following case number, CAS 88-10-2020.
Now, to cut to the chase, we know that investigation did not deliver any answers, but we do know from an affidavit filed by Advocate McAdam in the litigation that you launched in July of 2021, McAdam filed an affidavit. The lady is reflected in paragraph 166, although that date can't be correct because it says 24 May 2021. We'll get the correct date to your ladyship. But just disregarding the date, Mr. Kalata, can you read into the record paragraphs 166 and 167?
Yes. Judge, paragraph 166 reads as follows. Advocate McAdam filed an affidavit dated 24 May 2021, but that will be corrected, as part of the NPA's Rule 53 record in case number 35447/2021 Gauteng Division. In this affidavit, he indicated that during April 2013, he was Deputy Director of the Priority Crimes Litigations Unit, and Advocate Sean Abrams was the acting head. They received a request for information about the Cradock Four case from a Miss Lipinka, who was the personal assistant to acting National Director of Public Prosecutions, Advocate Gqeberha. Abrams responded to the request, and shortly thereafter, McAdam was asked to hand over the investigation docket, Swartskop CR 13/07/1985, to the office of the acting NDPP, which he did. McAdam then avers that at a certain stage, without disclosing a date, that Advocate T.P. Pretorius SC, then acting head of the PCLU, asked him for the Cradock Four docket, and he advised Pretorius that it had been uplifted from our office and was missing. McAdam did not disclose why Pretorius was seeking the docket. This exchange must have happened between 2016, when McAdam returned to his normal duties after working on foreign bribery cases, and April 2019, when he assumed the position of acting head of the PCLU.
Thank you. Milady, we will get you the reference to the affidavit of Advocate Christopher McAdam in the Rule 53 of the civil application. I've just noticed that in the outstanding documents index, the wrong McAdam affidavit is reflected. That's an affidavit he filed in the Rodriguez application for a permanent stay of prosecution, but we will locate the reference for the Rule 53 affidavit in due course. In the meantime, I can refer this Honourable Court to the supplementary founding affidavit that Mr. Kalata filed on the 26th of October 2021 in response to Mr. McAdam's affidavit, and that's at page 587 of the outstanding documents bundle. Now, you say in your statement that from what was said in Advocate McAdam's Rule 53 affidavit, it was evident that no investigations on the Cradock docket occurred between 2013 and 2019 when Advocate McAdam took steps to assist the investigating officer to reconstruct the docket. That was a period of some 6 years. What's your reaction on learning that between 2013 and 2019 there was no docket available upon which to carry out investigations?
Ma'am, by then, I think it was obvious to everybody that the case of the Cradock Four was quite a significant and emblematic case in South Africa over the years. You heard yesterday, ma'am, that it really, on the afternoon of the Cradock Four's funeral, the government of P.W. Botha had declared a state of emergency. It was, I had, over the years because of my job, I've met several senior and high-profile individuals. And most of them, once they would always ask me if I was related to the Gqelatas from Cradock. And when they would ask me if, what my relationship was to Fort. And whenever I would tell them that, Fort was my father, many of them would actually recall that, hey, I was in Cradock that day, and then they would then regale me with stories. Sometimes I wouldn't have the time because I would be there in my capacity of a journalist, so I would have, kind of play nice and say, yes, but I'm here for work, but neither. Anyway, man. So for me, what had become clear was that between 2013 and 2019, nothing, like absolutely nothing had happened with the Cradock Four case. There were, whatever investigations there were, had stalled because nobody knew where the docket was between 2013 and 2019. So nothing happened, like absolutely nothing happened with the case. Whatever investigations Makua and Masekela had made prior to that had basically been in vain because the case was, the docket wasn't even, they didn't even know where the docket was now.
Thank you, Mr. Kanata. Milady, just going back to the affidavit of Christopher McAdam, we have located it. It is at page 1255 of the outstanding documents bundle. So that would be, I believe, the second volume that we've handed up to your ladyship. And I see it is in fact dated 25th of May 2021. So I'm assuming that Mr. McAdam made out that affidavit as part of the police investigations into the missing docket. Now, at paragraph 170 of your statement, Mr. Kalata, you make reference to Advocate McAdam's affidavit, where he says in his statement that the missing docket only comprised of an inquiry into unfounded rumours around one General Hankel, and then the inquest and TRC records, which were easily re-obtainable. And then you point out in your statement that, well, if that's all the docket contained, as suggested by Advocate McAdam, then it reflects that little or no investigation was taking place because besides the publicly available records, there was next to nothing which suggested an investigation. And you said that means that there has been no real substantive investigation in this matter for more than 20 years. When you learned that, what was the impact on you?
So, as I had mentioned earlier, Judge, we, from about 1995 onwards, when Madiba came to Cradock, we were certain that justice was going to come in some form or the other. But then nothing had happened. Absolutely nothing had happened. And when we were speaking to the NPA and McAdam and everybody else, and it became apparent to us that even the docket had gone missing, it almost like snuffed most of the hope that we had really, because it just proves that people weren't interested, that people didn't care. They were busy with democracy and corruption and all of those things, but they didn't care in terms of how we got that democracy.
So, moving on, it seems that you decided to take some steps. You point out in paragraph 172 of your statement why you decided to institute litigation in this matter. Perhaps you can read paragraph 172 into the record.
Page 172, paragraph 172 reads, some 2 years after liaising with the NPA and the DPCI and twice placing them on terms during 2020 to finalize the murder investigations, it became clear that the NPA and DPCI were making very little headway. The Cradock Four families instructed our lawyers to launch an application to court for an order compelling the authorities to finalize the missing docket investigation, as well as to take a decision on the murder case. This application was launched on 20 July 2021. That was to mark the 36th anniversary of the burial of the Cradock Four. Ma'am, can I just state also that by then I now had legal backing. I had lawyers, and I was basically prepared to give the government a punch in the nose because I didn't know what else to do. So, and that's what we set out to do.
So, through this process, you and the families were able to extract documentation from the NPA and DPCI in the course of the review process. And you set out in paragraph 174 that this disclosed the dire state of the investigations, but it did force the prosecution and investigation teams to work closely with the family team, and that then resulted in the litigation being held in abeyance. But by then, suspects were elderly and dying off. And in fact, we'll get to that shortly. But you note the death in May 2023 of Hermanus Baron du Plessis, the last remaining suspect against whom there was a prima facie case. So with his death, talking of a punch in the nose, what was the impact on you hearing about that?
Judge, the death of Hermanus du Plessis was a punch in the gut. Because up until that point, there were still suspects where there was prima facie evidence against them that could be prosecuted. So, if I can just recall the day, Judge, when I went to the office and got to the office, set up, opened my laptop and then started working, and then just as I was about to work, an email came in. And the email was from our lawyers from CDH, basically saying that Hermanus, the last suspect that we, for an actual prosecution had died. Now, up until then, ma'am, I was really operating like tunnel vision, like this, and I was just pushing for a prosecution of some kind, because that at that point would have been justice to us, someone being held accountable for the murders of the Cradock Four. I think by then, we had some encounters with Advocate Yanni Coltman, and he'll tell you, man, that sometimes I'm not a very easy person to deal with. So when I got that email, my heart started racing, like do. I struggled to breathe. I didn't I got drowsy at my office. And I didn't know what was happening, ma'am. And fortunately for me, my managing editor at the time, Zain Samar, he had a good eyesight to where I was, and he saw that there was something wrong with me at that time. So he came to my desk, and we spoke a little bit, and I was, in between breaths, I was able to explain that I can't breathe. And then he took me out of the office, took me to the boardroom, and where, he managed to calm me down. And I thought I was having a heart attack because I had a massive pain in my chest, and then he said I must go home. I called the doctor, and fortunately she could see me, and I calmed down a little bit. I went to get my car and I drove myself to the doctor. And I got there and I was telling her my symptoms. I couldn't breathe. My heart was racing. There was almost something was pressing on my chest. And she did tests. She put stuff on me. A whole lot of tests. After about half an hour, she came back with those tests, and we sat, and she told me that physically I was fine. My heart was in rhythm. Like my blood sugars and stuff, they were all within the limits. I was good physically. But then she said, but what happened? And that it sounded like I had had a panic attack, and she asked me what happened. So then I explained to her that no, I received this email, and it said that the last suspect in my father's murder had died, and that his death meant that justice in the traditional sense of somebody being held accountable for my dad's murder, that door was now closed to us. And the doctor, bless her heart, she said to me that I had a hole in my soul that needed healing, ma'am. And she asked that I see a counselor. And from...
Do you want to carry on, or would you like to take some time?
I'll be fine.
Don't you want to take a seat? It's 5 to 1. Would you rather take the lunch adjournment at this stage?
My lady, yes, it is almost 1. We're not far from the end, but maybe this will be an appropriate time for the lunch adjournment.
Okay, would you adjourn for lunch?
That's not normal private frolics, those, man.
And if I can refer you to the State Security Council meeting of the 10th of June, 1985. And this is just 3 days after the sending of the signal. Deputy Law and Order Minister Flock says that there are certain problems and he's going to take certain steps. Could you read into the record your paragraph 143, please?
143 reads as follows, Judge. As pointed out by the advocate, just 3 days after the sending of the signal, Flock reported to a State Security Council meeting held on 10 June 1985 that he had spoken to the chairpersons of the Joint Management Councils, and they had problems with departmental representatives not having the necessary mandates or delegations to act on their own initiative. I thought I was having a heart attack because I had a massive pain in my chest, and then he said I must go home. I called the doctor, and fortunately she could see me, and I calmed down a little bit. I went to get my car and I drove myself to the doctor. And I got there and I was telling her my symptoms. I couldn't breathe. My heart was racing. There was almost something was pressing on my chest. And she did tests. She put stuff on me. A whole lot of tests. After about half an hour, she came back with those tests, and we sat, and she told me that physically I was fine. My heart was in rhythm. blood sugars and stuff, they were all within the limits. I was good physically. But then she said, but what happened? And that it sounded like I had had a panic attack, and she asked me what happened. So then I explained to her that no, I received this email, and it said that the last suspect in my father's murder had died, and that his death meant that justice in the traditional sense of somebody being held accountable for my dad's murder, that door was now closed to us. And the doctor, bless her heart, she said to me that I had a hole in my soul that needed healing, ma'am. And she asked that I see a counselor. And from...
You want to carry on, or would you like to take some time?
I'll be fine.
Don't you want to take a seat? It's 5 to 1. Would you rather take the lunch adjournment at this stage?
Milady, yes, it is almost 1. We're not far from the end, but maybe this would be an appropriate time for the lunch adjournment.
Okay, go to Legend for lunch.
These murders, and the bodies from the car, I think that they spread them out as far as they could, but also so that they could not be linked back to the car that we knew that, or that they knew belonged to Gqeberha. I just think it was just a ploy, Judge, to try to hide the crime and to deceive those that would be investigating, from failing to make the necessary connections in this whole matter.
And Mr. Kalata, what was the public explanation that the police and the authorities made for these murders?
At the time, Judge, the explanation that was made was that the Cradock Four could have perhaps been killed by a Zapo, and that it was black on black violence, infighting, I suppose, between the different liberation movements, between the African National Congress and the Zapo and all of those.
Mr. Kalata, you make that point of this fabricated story at paragraph 66 of your statement.
Milady, at page 29 of the Lukhanya Kalata bundle, there is a finding from the Truth Commission to this effect. And we also refer your ladyship to page 72 of the same bundle, which includes Saki van Sel's amnesty application. And we refer the court to paragraph 9, where Saki van Sel says that this was the plan, that they would be blaming it on Zapo. Mr. Kalata, let's now turn to the attempts to get to the bottom of the murders, starting with the first inquest, which you deal with at paragraph 68 on page 24 of your statement. Perhaps you can just read into the record the ultimate finding of Magistrate Gqeberha, which was handed down in February 1989.
I'll read the entire paragraph.
You may.
Judge, paragraph 68 reads as follows. In February 1989, an inquest into their deaths was held at New Brighton, Port Elizabeth by Regional Magistrate Gqeberha. Inquest number 626/87. The families were represented by Advocate Arthur Chaskelson SC. Despite evidence pointing to state involvement, the magistrate found that the Cradock Four's deaths were brought about by a person or persons or a group of persons unknown.
Mr. Kalata, you would have been too young at the time to have your own reaction, but looking back at that finding, how did the families respond to that particular finding?
You know, it's interesting because we were talking about it in the bus when we were doing the in loco inspections just this week. It was preposterous, Judge, that my father and his comrades were killed in the heinous and brutal way in which they were killed. But for Magistrate Gqeberha to find that they were killed by persons or a group of persons that were unknown. There was something very interesting, Judge, and I hope I can say this, but that Mrs. Mkhawuli mentioned in the bus, and we'd actually, we'd never heard it before. But she mentioned that that entire first inquest was conducted in Afrikaans, and she doesn't speak Afrikaans. My mother speaks Afrikaans. So all four of the widows at the first inquest basically were saying to her the whole time, "Nomonde, what are they saying now?" And then my mother would have to translate. Sometimes my mother wouldn't hear what was being said, and then she would just tell them that she couldn't hear. But there was a small little anecdote, obviously because it was a very serious discussion that we were having in the bus. But Ms. Mkhawuli had a small anecdote, and she says that the only thing that she remembers was this young lawyer. I forgot his name. I think his name, she mentioned Cobus. And all she remembers was Cobus just going, "Akhbar, Akhbar," because he was trying to get some form of, I suppose, postponement or leniency or something to get the judge to try to understand that, this was all happening so fast. They didn't understand what was going on. And really, it was really funny in the bus when she kept on saying that her only memory was, Akhbar, Akhbar.
Mr. Kalata, let's turn to the second inquest. Can you explain to the court how it was that a second inquest came to be held? The second inquest came to be held after the New Nation newspaper published an article on the 30th of April 1992 that revealed a top secret military signal
that had called for the permanent removal from society of Goniwe, Kalata and Lumbulelo Goniwe. Now, as a result, the Minister of Justice instructed the Judge President of the Eastern Cape Local Division, Neville Zitzman, to reopen and preside over that inquest. If I may, Judge, when I was working at the SABC, I worked for the SABC as a parliamentary reporter in Parliament. And I used to sit next to my colleague, Umanelisi Dubase. And he told me the story once that he was working for the New Nation newspaper at the time, and how they were sent by their editor. 2 reporters were sent by the editor. They had received a phone call from General Bantu Olumisa, and he had informed them that he had this dossier which included this signal. So the editor sent them down to Mthatha, and one of the reporters was actually given the dossier, but then they drove different routes to get back to Johannesburg. He says that his colleague who had the dossier drove, I think, through Mthatha to Durban and then on to Johannesburg, and then he drove through Cradock because they didn't know if they were being followed, and to obviously, if something happened to either one, maybe if the security branch or if the police were to attack one of them, they didn't know which one had the actual information, and that's how the New Nation got this actual dossier from General Bantu Olumisa.
Thanks for that anecdote. Milady, I understand that my learned friends for Mr. Mbilele Gqeberha and the community will be calling General Olumisa to testify in this inquest at some future date. So let's return to the second inquest, Mr. Kalata. And can I ask you to read into the record certain conclusions reached by Judge President Zitzman? And let's start with his findings at paragraph 72 and 73, please.
Right. Paragraph 72 and 73 reads as follows, Judge. Judge President Zitzman concluded in his judgment 1994 SA 877 SECLD that the deaths of the Cradock Four were brought about by deliberate acts committed by an unknown person or persons, which acts constitute murder on the part of such person or persons. But the judge was unable to conclude that it had been established prima facie that the murderers were members of the security forces.
Just a small question, a small correction, but the judge was able to conclude.
Oh, yes, sorry, Judge. 73, but the judge was able to conclude that it had been established prima facie that the murderers were members of the security forces. Apologies on my part on that, Judge.
No problem. And then if we can ask you to also read into the record certain other findings that Judge Zitzman made in his judgment. And I draw your attention to paragraphs 76 and 77, and please read those into the record.
All right. Paragraph 76 reads as follows, Judge. Judge Zitzman noted in his judgment that Colonel Lawrence du Plessis, who authored the signal, understood the instruction in the signal to mean kill. At pages 42, 72 to 73, the judge found at pages 74 to 75 that in my opinion, it has been established prima facie that the signal was intended by Colonel du Plessis to mean that Matthew Goniwe and the others should be killed, and also that this is the meaning that Brigadier van der Westhuizen intended should be conveyed in the signal. Judge Zitzman concluded, it has, in my opinion, been established prima facie that the murderers of Matthew Goniwe, Sparom Konto, Fort Talat, and Sicelo Mhlawuli were members of the security forces. A case of suspicion has been made out against certain members of the police force, including Colonel Snyman and Colonel Winter, and against certain members of the South African Defence Force, including Brigadier van der Westhuizen, Colonel du Plessis, and Major General van Rensburg.
Thank you, Mr. Kalata. Now, at that time, to the best of our knowledge, all the named individuals, at least that those against whom the learned judge found there was a case of suspicion, were alive. What did you and your families expect to happen after those findings were made in that inquest?
Judge Neville Zitzman delivered his judgment, I think, on the 28th of May, 1994. It was shortly after former President Nelson Mandela had been sworn into office on the 10th of May as the first democratically elected President of the Republic of South Africa. So we had expected, Judge, that with the findings of the second inquest, that there would be prosecutions, that people would be held accountable for murdering our fathers and obviously our mothers' husbands. There was a lot of hope, Judge, that in democratic South Africa we would finally receive justice, because now there was a court then that had said that these are some names who were suspected of having been involved, and that, you know, they needed to be prosecuted, or there was at least a suspicion. And we thought that justice would then follow in the form of prosecutions, Judge.
So, just so that you're aware, Mr. Kalata, the case of suspicion isn't high enough for, it doesn't meet the threshold for a prosecution, but it's certainly a basis for investigations. Yes. So the families were expecting some vigorous action and investigations, as I hear you saying.
Yes, of course. So we can't all be lawyers, I feel. So, in our estimation, if there's a suspicion, then obviously the state must do what it has to do, but that ultimately, you know, that the steps would then follow, which would ultimately then lead to charges being laid, prosecutions, and then convictions. Right. Yeah.
Mr. Kalata, if you ever tire of journalism, there is a career waiting for you in law.
I agree.
I appreciate that, ma'am.
Let's now move to what happened before the Truth and Reconciliation Commission. And the Truth Commission itself, through its own investigations, made certain findings. We know that, you point this out in your statement at paragraphs 80 and 81, that the wives, your mother and the other wives, testified before the TRC, and we're going to be hearing from some of them. The Commission made an important finding, Mr. Kalata, and you reflect that at paragraph 82 of your statement. Could you read that into the record, please?
Judge, paragraph 82 reads as follows. The TRC noted that an attempt was made by the state to suggest that the deaths of the four were the result of ongoing and violent conflict between AZAPO and the UDF in the Eastern Cape. The Commission found evidence that this fabrication was formulated by the Strategic Communications Branch, or STRATCOM, of the State Security Council's Secretariat. The Commission found that the attempt to lay the crime at the door of AZAPO in the Eastern Cape was not only a case of disinformation, but a deliberate attempt to stoke conflict that had already claimed lives in the Eastern Cape.
Lady, we give the reference for that finding in the statement. It's at volume 2, chapter 3 of the final report of the TRC, paragraph 251. Now, Mr. Kalata, you've already indicated to this court that several of those involved in the murders applied for amnesty. In paragraph 84, you mentioned those names, and since they are already on record, I won't ask you to repeat them. Milady, for your convenience, that TRC finding is actually at page 29 of the Lekanya Kalata bundle. But I will ask you to read into the record certain findings made by the Amnesty Committee. And can you read into the record paragraphs 85 and 86 of your statement?
Yes, certainly. Judge, paragraphs 85 and 86 read as follows. The TRC Amnesty Committee, in its ruling, Amnesty Committee Decision AC/99/0350 of 14 December 1999, found that the foot soldiers who actually perpetrated these deeds acted on the instructions of Nicholas Janse van Rensburg and Hermanus du Plessis, who supported and approved the killings. Paragraph 86, Van Rensburg in turn received instructions from Harold Snyman. In tracing the chain of command, the committee found that the order from Snyman that the best must be done for the country meant that he approved of these assassinations. Minister Legranji told Snyman in a conversation that a plan needed to be made regarding the unrest in the Eastern Cape. Snyman interpreted this as an order to assassinate those leaders directly responsible for the unrest.
Thank you, Mr. Kalata. Milady, we give the references in the amnesty decision in those paragraphs. So for paragraph 85, it's page 2, lines 18 to 19. And for paragraph 86, it's also page 2, lines 20 to 27. And we also have that decision. My learned friend tells me that it's at page 32 of the Lekanya Kalata bundle. Mr. Kalata, you set out in some detail facts that emerges from the amnesty application of Saki van Zyl, the nature of the orders he received from Snyman and van Rensburg. Milady, just to keep the court informed, or just to remind the court, Snyman was the then head of security branch in PE, in fact for the region. Nicolaas Janssen van Rensburg was his second in command, and Hermanus du Plessis was head of Black Affairs for the security branch. Mr. Kalata, can I refer you to paragraph 88 of your statement, where you refer to an exchange between Minister Lacranje, the Law and Order Minister at the time, and Mr. Snyman. And since that is an important exchange, can I ask you to read that paragraph into the record?
Judge, paragraph 88 reads as follows. In Snyman's application for amnesty, he referred to a safety and education meeting held on approximately 14 February 1985, at which Minister Lacranje approached him during an adjournment and told him that he was expected to make a plan with the agitators in the Eastern Cape. He understood this to mean that Gqeberha and others had to be killed. This was especially so since, according to Snyman's affidavit, it was discussed and recorded at this meeting that the normal legal options were no longer a solution for the problems faced in the Eastern Cape.
Milady, Snyman's application for amnesty are reflected at items 18 and 19 of the Lekanyo Kalata bundle, pages 79 through to 91. And Mr. Kalata, the TRC Amnesty Committee made a finding in respect of the plan to murder the Cradock Four, and you reflect that at paragraph 89 of your statement. Can I ask you to read that finding into the record?
Paragraph 89 reads as follows, Judge. The plan devised by the applicants to murder Gqeberha was then put into operation. Johan Martin van Zyl, also known as Saki, was charged with handling the operation, which included the execution of Gqeberha. The murders of the Cradock Four would be made to look like the result of a vigilante attack. Indeed, it seems that the manner in which the murders were committed confirms that part of the plan. In order to execute the murder, he elicited the assistance of Eric Alexander Taylor, Gerhardus Johannes Lotz, as well as the late Sergeant Faku, Goduga, and Sakati.
Now, Mr. Kalata, we're aware, and as you point out at paragraph 90, that all the applicants for amnesty, with the exception of Eugene de Kock and Jaap van Jaarsveld, were refused amnesty. What was your reaction and that of the families to the refusal of amnesty?
Again, Judge, our understanding was that when someone was refused amnesty, prosecutions would follow. If I may add, Judge, on either the 4th or the 5th of June 1995, former President Nelson Mandela came to Cradock to come and lay a wreath at the graves of the Cradock Four. And he obviously spoke there about how our fathers were the real heroes of the struggle against apartheid, or the struggle for freedom. It was shortly after, I think, about 2 months after he was in Cradock, that he then signed the Promotion of National Unity and Reconciliation Act into law. And that was the act that then paved the way for the TRC. And we, at the time, my mother and them, they met with lawyers, and we were made to believe that part of that was that if someone has been denied amnesty, they can then be prosecuted if they're denied amnesty.
So that was the expectation of the family?
Yes, that was definitely the expectation, Judge. Definitely.
And Mr. Kalota, my team will be providing the dates of death of all those refused amnesty. But to the best of my knowledge, at the time they were refused amnesty in 1999, with the exception, I believe, of Harold Snyman, they were all alive and potentially could have faced justice. And yet here we are, many years later, and we know that they didn't face justice. So how did that impact you and your families?
First of all, are you in a position to confirm that indeed was the case, that they were still alive at the time, except for maybe one?
Ma'am, Gerardus Lots, yes, I can confirm that he was alive. When he died by committing suicide, I was already I'd been working as a journalist for a while, and I think I was either at the SABC or potentially by then at ETV News and Sport. It was one of those, ma'am. But I remember having reported on the death by suicide of Gerardus Lots, and that was much, much later than 1999. So I can definitely confirm that. Eric Taylor, Eric Taylor died in November 2016. This was confirmed to us by Dominee Charles Kutsia, who is one of the witnesses that will be called. So I can at least confirm those two. And then was it Baron Duplessis who died, I believe, in 2023, in May 2023. So those three, by then I was working as a journalist, so I can confirm at least those three off the top of my head, Judge. Sorry, what was the question?
Milady, I believe the death certificates are in the record, and once we do have the final paginated bundle, indeed my junior has told me that the death certificates are in volume A of the current bundle. A72 is the death certificate of Josef van Rensburg, A73 that of Lotz, A74 of Taylor, A75 of Snyman, A76 of Hermanus Barend Duplessis. And during the course of the day, we will extract them and bring them to your attention together with the dates of death. So we're aware that most of those refused amnesty were alive for several years after they had been denied amnesty.
Yes.
And the fact that no action was taken against them, they were allowed to die peacefully, in a sense.
Yeah.
What was the impact of that on your family?
Ma'am, so these guys had we get to interact with Afrikaans people, English people, white people on a daily basis. From there, we are able to understand that family means a lot to Afrikaners, to English people, and that their whole lives center around family and the importance of family. So what I could never understand is that if this community places so much value and emphasis on family, why was it so easy for them to just tear our families apart? Because Fort was my father, Judge. And it didn't matter that he had a black skin, because a father in a black family holds the exact same significance as a father in a white family. A husband in a white family holds the exact same significance in a black family. So, why did our families not matter? Why could it be that they could desecrate my father's body in the manner in which they desecrated him, and for that not to mean anything? So,
For no action to be taken, is that what you mean?
Yes, ma'am. So we struggled, and we continue to struggle to understand why there was never anybody held accountable for ripping our families apart. And that's a daily struggle, ma'am. And I'm trying to stand here and be strong. But when I talk about it, ma'am, it makes me really emotional, because of the struggle and the pain that we have had to endure for nearly 40 years now, ma'am. Advocate, I don't know how to explain it. But
Mr. Kalata, your anguish and your loss of words is totally understandable.
thank you.
Let's move on, Mr. Kalata. You make reference in your statement to the Motherwell bombing connection. What is the connection between the Motherwell bombing, if you can explain what happened in that case, to the case of the Cradock Four, or the possible connection at least?
Yeah. Ma'am, what we know about the Motherwell bombing was that it was a car that exploded whilst transporting 3 police officers, and these officers were Sergeants Faku, Gotuga, and Sagat. And these were the same sergeants that were implicated in the murders of the Cradock Four.
And I see in your statement that that particular bombing took place on 14 December 1989 at or near Motherwell, which is a district of Port Elizabeth. And certain individuals applied for amnesty. Perhaps you can just read into the record paragraphs 93, 94 and 95, which seems to establish the connection with the case, with the Cradock Four case.
Paragraphs 93 to 95 read as follows, Judge. Some of the amnesty applicants were associated with the murders of the Cradock Four, including Gerardus Jacobus Lotz, Nicholas Janse van Rensburg, and Eugene de Kock. All were refused amnesty. The Amnesty Committee found that the reason for killing the deceased was to prevent them from disclosing allegations of fraud within the special branch and to conceal the illegal activities of the security police. Major General Nicholas Jacobus Janse van Rensburg testified in his amnesty hearing that Gideon Nieuwhout, who was also refused amnesty for his role in the Motherwell bombing, was concerned that the 3 policemen could divulge details of their involvement in the murders of the Cradock Four.
The lady at items 21 and 20 and 21 of the Kalata bundle, pages 92 to 95, the extracts from the amnesty decision in the Motherwell case is included. Mr. Kalata, in your statement, you appear to reach the conclusion that this was not just an incident that happened at the local level, but that the State Security Council system was implicated. And from page 31, you set out in some detail why you reached this conclusion. And you give some background to the State Security Council and its structures. I'm going to ask you to read into the record a few of those paragraphs, starting with paragraph 100 and 101.
Paragraph 100 reads as follows, Judge. The State Security Council was a special cabinet committee on security set up in 1972. In terms of the Security Intelligence and State Security Council Act, Act 62 of 1972, the SSC was composed of the State President as chairperson, senior cabinet members and members of Foreign Affairs, Defense, Law and Order, and Justice, the Chief of the South African Defence Force, and Commissioner of Police, as well as the Director Generals of National Intelligence, Foreign Affairs, and Justice. In addition, the State Security Council was empowered to co-opt ministers and officials of other departments on a permanent or ad hoc basis. In terms of Act 62 of 1972, the SSC was to play an advisory role to Cabinet regarding the formulation and implementation of national security policy, policy regarding the combating of any specific threat, and intelligence priorities.
You can also read paragraph 101.
Paragraph 101 reads, however, the State Security Council assumed decision-making powers far beyond the advisory powers conferred upon it in the Act. It was in the SSC and not Cabinet where matters of greatest sensitivity and importance were deliberated and agreed upon, with Cabinet merely providing a rubber stamping role.
The lady, much of the section of Mr. Kalata's affidavit is reliant on the Truth Commission report, and we will provide you with the references. And also another report prepared during 1997 by the Civilian Support Component of the Investigation Task Unit, titled The Apparatus of State-Orchestrated Violence in Apartheid South Africa. And the lady, that report is reflected at item 22 of the Kalata bundle from pages 96 to 218. Mr. Kalata, you make reference to the Deputy Minister of Law and Order, who at that time was Adrian Vlok. And you explain his designation and role at paragraph 103. Can you just read that into the record?
Yeah, surely. Paragraph 103 reads as follows, Judge. The State Security Council was assisted by a working group which was chaired by the Deputy Minister of Law and Order. and which included the Secretary of the SSC, as well as the heads of departments represented on the State Security Council.
And you point out that the State Security Council was not just one council, but it sat at the head of a body known as the National Security Management System. Can you read into the record your paragraph 105?
Paragraph 105 reads as follows, Judge. In August 1979, the establishment of a National Security Management System was officially announced. The NSMS was a vast bureaucracy intended to coordinate all the arms and departments of the government in a united and total effort to counter the perceived total war against South Africa. It was through the NSMS where the doctrine of the total strategy was embraced and expounded, and where actions, both legal and illegal, were authorized.
Now, we don't have time to go through all the different entities connected with this state security system, but I do want you to focus on two entities that you refer to in your statement, namely that of Stratcom and a group known as Trevitz. So let's start by asking you to read into the record paragraph 107.3 and paragraph 108.
All right. 103 all the way to 104.
Take it through to the end of those subparagraphs.
All right. Paragraph 107.3, Judge, reads Strategic Communication, or Stratcom. Stratcom developed strategies to combat the total onslaught. One of its aims was to discredit anti-apartheid organizations, neutralize anti-government publicity, and promote a positive image of anti-communist groups by using the Bureau of Information to overtly sell the government message. And secondly, it employed covert propaganda through other entities. Stratcom also had a more sinister component, Judge, which included the use of murder, intimidation, economic sabotage, character assassinations, and front companies against anti-apartheid personalities and organizations. Stratcom was directly accountable to the State Security Council, while projects which focused on a specific sector of society had to be approved by the relevant minister.
And actually, we can now skip to paragraph 108.
All right. The other State Security Council committees, this is paragraph 108, Judge. The other State Security Council committees included the Coordinating Intelligence Committee, known as KIK, from its Afrikaans name, Coördineer Inligting Komitee, and Counter-Revolutionary Intelligence Task Team, known as Trevitz, from its Afrikaans name, Teen Revolutionaire Inligting Taakspan.
And please read the subparagraphs as well.
KIK, also known as the K Committee, was established in early 1981 and was chaired by the recently deceased Neil Barnard. Its function was to coordinate activities and intelligence between all intelligence agencies and the non-security agencies. It had several subcommittees including covert collection, later called Trevitz, open information gathering, technical evaluation, later became NIIB, and counter-espionage and security intelligence. Now, Trevitz, also known as Section J, was formed in 1985 to identify targets for action and elimination. It gathered intelligence for these operations. Trevitz was under the command of the security branch, but included members from the NIS, DMI, and Special Forces. Trevitz interacted with the Joint Management Centers through the VACOM security committees.
Thanks.
Oh, sorry, it's FACOM. I would imagine it's short for Veiligheidscommittee, Judge, in Afrikaans.
That's correct. And my letter, of course, NIS stands for National Intelligence Service, and DMI stands for Department of Military Intelligence. Now, if we continue, Mr. Kalata, and turning to the joint management centres, which operated under this system, you make reference in paragraph 110 to the fact that it was divided between two arms, the security management system and the welfare management system. Let's focus on the first one, the security management system. And in paragraph 112, you describe how these joint management centres or JMCs worked. Please could you read into the record that paragraph?
Paragraph 112 reads as follows, Judge. Through a hierarchy of 500 regional, district and local joint management centers, JMCs, these State Security Council directives were translated into practical actions on the ground. Representatives of the South African Police, the Security Branch, the South African Defence Force, provincial and local government sat on these bodies, but they were dominated by the security sector.
And in the very next paragraph, you describe the actual structure of the JMCs. Please could you read that paragraph, sub-paragraphs into the record?
Paragraph 113. The JMCs were the hands and feet, as well as the eyes and ears of the State Security Council on the ground. They oversaw and coordinated the daily implementation of strategies flowing out of the State Security Council. The joint management centers also continuously fed intelligence and situation reports back up to the SSC. The JMCs were structured as follows. The National Coordinating Committee, 11 JMCs regional, which replicated the South African Defence Force command regions, 60 sub-JMCs, these were the districts, 350 mini-JMCs, these sat at municipal level, and then numerous local government management centers at police station and commando level.
Yes, that actually reads local management centres.
Yeah, local man.
And then if we carry on, Mr. Kalata, the work of these JMCs, and I draw your attention to paragraphs 116 and 117. Could you read those two paragraphs into the record?
Yeah. Paragraph 116 and 17 reads as follows, Judge. The primary role of the JMCs was to collect intelligence on persons and groups who acted against the interests of the state. Information would be sent up the chain of command from the lowest level to the JMC, then the SSC and its working committees, and finally the Prime Minister or State President. The JMCs reported on the activities and location of political activists to form an overall security profile to facilitate decisions on security actions to be taken. Such actions included the harassment, torture, abduction, and elimination of persons opposed to the government. A secondary and neglected role was the hearts and minds strategy involving socio-economic and political steps.
Thank you, Mr. Kalata. Now let's turn to some of the findings that the Truth and Reconciliation Commission made against the State Security Council. And perhaps the most important one is reflected at paragraph 118 of your statement. Could you read that finding into the record, please?
Paragraph 118 reads as follows, Judge. The TRC concluded in its final report that the State Security Council played a central role in the regime's shift from a legal response to an extra-legal response to the growing threat to the apartheid state. However, in the 1980s, when the state was in crisis, it became clear that the law had run its course, that it could no longer do the job. The law had become ineffective, an apparent obstruction to the restoration of what government leaders, seemingly oblivious to the irony, called law and order. At this stage, real rule-making power shifted from Parliament and the Cabinet to a non-elected administrative body, the State Security Council, which operated beyond public scrutiny. Nominally, a sub-organ of the Cabinet, in reality, the SSC eclipsed it as the key locus of power and authority in matters relating to security.
And Mr. Kalata, there is a reference by the Truth Commission to a statement made by the former head of Security Branch Intelligence, Craig Williamson, and he attempted to explain to the TRC what explained this shift. Could you enter into the record that quote as reflected in the TRC report?
The quote under paragraph 119, Judge, reads as follows. A democratic state is often limited by its laws, values, and norms in the methods it can use to defeat an insurgent movement. Its solution is to resort to extra-legal counter-revolutionary acts as long as they are done secretly.
Milady, perhaps at the next session of this inquest, we hope to hear from Craig Williamson, who's one of the witnesses who has been subpoenaed to appear. Mr. Kalata, you also make reference in your statement to different kinds of words that have been used in state security documentation. Perhaps the one you're most familiar with is in the infamous signal that was sent on the 7th of June. But there have been other ones as well. If I can refer you to the bottom of page 39 in paragraph 120, where you point out that the state security documents never directly use the word murder, but other words. Could you read into the record some of these other words?
Yeah. Judge, the other words that were used were eliminatie, verwyder, neutraliseer, and uitwis, loosely translated as eliminate, remove, neutralize, and wipe out.
Now, the Truth Commission made a finding, a lady that's reflected in paragraph 121,
Paragraph 96, Volume 5, Chapter 6 of the Commission's final report.
Mr. Kalata, they made the following finding as you reflect that those in charge of the security apparatus reasonably foresaw that such words could be interpreted by members of the forces as an authorization to kill. And you set out in paragraphs 121.1 to 3 the basis for the Commission's finding. Please could you read those paragraphs into the record?
Paragraphs 121.1 to 3 read as follows, Judge. If the directives of the State Security Council and its structures were all lawful, as alleged by members like Mr. F.W. de Klerk, General Magnus Malan, and Dr. Neil Barnard, these would have been explicitly spelt out. If the intention was to detain, restrict, arrest, ban, or deport. These are the words that would have been used. Since the military and the police operated on a basis of clear and precise instructions, the words must have been intended to convey their normal meaning. There is no evidence of any attempt by the State Security Council to set in motion any independent, substantive, or comprehensive investigation into the killing of political opponents once this began to happen. Given that it was common knowledge that police investigations of such crimes generally took the form of cover-ups, neither did the SSC at any stage issue any statement or directive clarifying its orders and strategies to the effect that they should under no circumstances be interpreted as authorization for illegal activities.
Thank you, Mr. Kalata. Milady, I see it's 11 a.m. Would this be an appropriate time for the TH round?
Yes, let us take a break of 15 minutes. Continue adjourn for tea until 11:15.